Today's video feature is a discussion of contributory negligence and comparative negligence in personal injury cases. Now, this topic is certainly a little dry, it could even be a little boring, but it is so critically important when we're analyzing a personal injury case. Now, anytime you are injured in an accident, you immediately have damages, and those damages include your medical bills, your lost wages, pain and suffering, permanent disability, and things like that. But before we get to damages, we first have to look at liability, and that's critically important. Now, in cases where you're in a car stopped in the road and you're rear-ended by someone, liability is crystal clear. If you're a passenger, same thing, liability is not an issue. But in many cases where there's, say, an intersection crash or any number of other accident scenarios, we have to look at who's at fault. And in many cases, both sides share some degree of fault. Now, in North Carolina, we still have something called contributory negligence as a complete bar to any recovery. And what that means is, if you are at fault at all, you are barred by law in North Carolina to recover any claim, any damages, no matter how seriously injured or even if you were killed. Now, a lot of folks say, so 1%. Well, actually, it's even worse than that. For our math major friends, it's 0.0 1%. If you're at fault at all, you cannot recover under contributory negligence in North Carolina. Thankfully, South Carolina is a little more reasonable and a little more fair. We passed a law back in the early 90s. We call it modified comparative negligence. What that means is this: we compare the negligence of both parties. Okay, now if you are greater than 50% at fault, that means the accident would not have happened but for your negligence, and you are still barred in full, just like in North Carolina. But in South Carolina, you can be up to 50% at fault and still recover. However, any damages will be reduced by the amount or the percentage of fault that you are deemed to be. Now, obviously, a percentage of fault is not completely arbitrary, but it's also not very precise. And that is usually a determination made by a jury as to what percentage of fault you are at. Now, in the settlement negotiations, of course, we also have these discussions. And of course, if I'm advocating for an injured party, I say their comparative negligence is minimal, and I hear the opposite from the other side. But if you can, it's best to try to resolve these types of discussions through negotiations. Juries are not very sophisticated in assigning fault, and you just really have no idea what they're going to do. But I always remember that in South Carolina, you're still in the game up to 50%. If you're at fault at all in North Carolina, it is game over. Hope it helps.